number 99 of today's list, my lord.
99.
99.
Yes.
But this has been mentioned for extension of interim order.
Okay.
Let the matter appear tomorrow as extension of interim order, my lord.
Yes.
Zakir Hussain. Another is motion, my lord. Group 8. My lord.
May I be permitted to mention two matters? These two matters are criminal revisions, my lord. These two matters were last heard by your lordship on 21st of December and were reserved for judgment. Till date, judgment has not been passed.
No. There is.
Thus, judgments are not available in server.
Huh? Okay.
Lower court trial is also.
This judgment has been delivered, I think.
My lord, it's
Yes,
not
yes, this
available in
judgment
the
has been
server.
delivered. That is the case where there is an allegation of POXO.
POXO. My
Yes,
lord.
judgment
My
has
lord.
been delivered.
My lord,
I do not know whether
it is not in the server, my lord.
that I am today I am taking information, and server has already been made.
My lord, just now I checked, it is still now not in the server.
Let me see.
My lord.
Let me
My
see.
lord.
I shall talk to the registered listing.
Last Friday, my lord, Mr. Lolik Mahato appeared on matter and argued the matter.
Item number?
Last Friday, my lord,
Huh?
Mr. Lolik Mahato appeared on behalf of the state and
Yes, yes.
and your lordship directed him to produce some judgments, copy of
Okay.
the judgments.
Okay. ওকে, এটা হচ্ছে ওই যে ওই ম্যাটারটা
বনানী মিশ্র
বনানী মিস্ত্রি WPA নাম্বার 3178, ওটা WPA নাম্বার 3178। ওরা দেখে নিন যে আর্গুমেন্টটা বনানী মিস্ত্রি, দেখে নিন আর্গুমেন্টটা শেষ হয়েছে কিনা। এটার চেম্বারে পাঠিয়ে দিয়েছেন 30/6, তাহলে ওটা আমাকে ট্যাগ করে দেন।
May I have your lordship's kind
Yes.
information? Lord, this is a restoration application against a dismissal on 10/5/2023, my lord.
What is the matter?
It is a matter of police inaction, my lord.
Police inaction. Police inaction is I am not I do not have the determination of police inaction.
Then, my lord,
It's a residuary matter.
yes, my lord, it is a residuary matter.
So how it came and how it is dismissed? Okay, you file the restoration বিষয়, এটাকে immediately এনে দিন তো।
Grateful, my lord.
Yes, call the list.
Regarding lordship item number 1, regarding the quantum of amount, there is some dispute. I am taking with my contract. I am
No,
talking
it
with my
one.
client regarding one.
Iruddin Ahmed to one na Janip Mandal on.
Jenny,
Oh, check.
lordship, I am taking time day after tomorrow.
Lordship,
Regarding the quantum of amount, there is some dispute. I am talking with
Lordship,
my client, lordship.
I am filing contempt. Affidavit
On behalf of?
contempt.
On behalf of the contemptor, yes?
I appear for the petitioner, lordship.
Yes. What's the
Regarding-
matter? What's the matter about? What is the matter about?
The matter is about compensation
Huh?
regarding the land loser of lordship, regarding page 43, lordship pass an order, page 43.
The grievance of the petitioner as his homestead land was acquired by the public intention without initiating any proceeding or giving any compensation to him for construction of a water after original acquisition. The public requirement already constructed one water taken on the land of the petitioner. The petitioner made a representation for the sovereignty. I'm sure the settlement of that on similar circumstances This was personal direction, things in function, okay. This order was passed on. The date is practically, it is in the year 2020.
Lordship.
And thereafter, representation has not been considered.
Lordship considers
Huh.
the payment of rupees 7 lakh. The quantum of amount, I have some objection. I taking instruction to my client. I am making, kindly make it day after tomorrow.
Lordship, amount already paid.
Yeah,
Lordship, come to the page number 9.
Yes.
Affidavit of service, Lordship.
Affidavit of service or report?
This is the report. Lordship, in the last occasion, Lordship was pleased to direct me to file a report, Lordship. This is the report in regard to payment of the due amount, which Lordship will
So,
find.
Yes. What is
Page number 9.
what is the amount you have calculated?
Lordship, that Lordship will find from page number 4, Lordship.
Page number 4.
Second paragraph, pardon me, Lordship. First paragraph, Lordship.
Yes.
15,15,443.
Yes.
The clear calculation, Lordship will find from page number 6A must be, Lordship.
Yes, 6A. Yes, what is your
Lordship,
objection?
I have no copy, Lordship.
Lordship, I'm keeping.
I am taking.
Yes.
He has
Instruction,
received
Lordship,
it.
kindly make it to day after
There is
tomorrow. I am
nothing
taking
left as a
instruction, Lordship. I am
container,
taking
Lordship.
instruction to my client, Lordship.
Lordship.
Kindly make it.
The container has
tomorrow,
complied with the respondents have complied with the order.
I have no copy, Lordship.
Yes.
But
Okay.
order sheet is
You,
Kindly make
you
it day
give
after tomorrow.
you give him a copy, and thereafter I shall take it up. Day after tomorrow.
Lordship.
Day after tomorrow is Thursday. Thursday under the same heading.
Lordship, kindly passes our order because the report has already been filed.
Yes,
Lordship.
of course.
Lordship.
In compliance of the order passed by this court, the alleged contemners has filed a report, but the learned advocate for the alleged contemner has filed a report showing compliance of the order passed by this court in the above writ petition. Full stop. Next paragraph. The learned advocate for the petitioner submits that he has not received the copy of the report and he requests to verify the report as to whether proper calculation has been made or not with regard to the compensation. Full stop. The learned advocate for the alleged contemner is directed to file a directed to serve a copy of the report to the learned advocate for the petitioner. Matter be listed under the same heading on 6th July 2023.
Lordship.
Grateful, Lordship. Grateful.
Item number 2.
Milord, I am for petition, Milord.
Yes.
In the last occasion, Milord, it is directed. I am filing, Milord, affidavit of service. Let it be kept on record. Pursuant to the order, Milord, passed by earlier occasion, that is, Milord, 2nd May 2023. We have served the notice to hearing respondent number 789 and the state respondent
Yes.
as appointed by this honorable court.
Yes.
Before that, my lord, I am pointing out on 16 October 2015, the order was passed by Justice Sanjeev Banerjee against
16th
one.
October 2015.
Yes. Initially, writ petition was moved in the name, my lord.
Petition was dismissed for default on general. A restoration application was taken out by two of the petitioners, and though the applicants were represented on May 19, 2015, upon the restoration application was first taken up, they were not represented on July 3, whereupon the restoration application was dismissed for default. There is an application for restoration of the restoration application, and 8069 is an application for condonation of marginal relay. In view of the good grounds shown as to why the applicants were not represented on the relevant day were allowed, and this by recalling the order showing that since 9 is represented for immediate consideration in view of the good grounds as to why the applicants were not represented, and when the petition was dismissed for default, the order is recalled. It is recorded that since the restoration application has been filed with the original petition number 2 and 3, with the other petitions are not only enforced on the petition, it will be regarded for the petition to be continued by the second and third petitioners. The names of the other petitioners stand deleted, and the petitions will carry the appropriate amendment. Yes.
Now, my lord, the previous petitioner, respondent number 789 was deleted, their name. And now only Sapon Saha and one another was in the writ petition to continue.
Yes.
And in the last occasion, the last respondent, Ajoy Saha, was present. And my lord, the court, pursuant to the order of the 2nd May 2023, we have served the copy. This court is appointed to lawyers, Mr. Mahato or something else. We have served copy and affidavit of service is.
Yes.
But what happened? The petitioner are the brothers of the. There are 6 brothers and 2 sisters. Others' property have not been partitioned. Now, my lord, the respondent, without giving them any opportunity of hearing, the property was recorded in the name of the other 3 brothers.
So,
therefore, my lord, I am only asking to set aside.
so it is a dispute relating to recording in the record of rights.
No, my lord, governor has issued the allotment. It is a refugee property, and according to the law, they have allotted the property without giving any hearing to the other co-owners. The property was not partitioned.
Now, your case is that by way of this refugee rehabilitation
Yes.
that act, the governor gave patta to all the to the predecessor in interest of the petitioners and the private respondents.
No, not all, my lord.
So some of the private
Oh,
respondents.
yes, 2 or 3.
Now the
Yes.
original owner, original patta holder died, leaving behind 6 sons and 2 daughters.
sons.
Now
Let them give hearing.
only one the property was recorded in the name of only one person.
Yes.
In the record of rights. It is your case.
Record of rights, no, my lord. Governor has directed the allotment of the property in the name of the 2 co-sharers or 3 co-owners, without giving any opportunity of hearing, without any notice. That is why I am submitting, my lord. Let the order be set aside and directed.
No. That your petitioner's father, Brojagopal Saha,
Yes.
please.
He got 6 sons and 2 daughters.
Was compelled to leave East Pakistan at the time of communal disturbance, and his family settled in West Bengal, occupied a plot, vacant land at Jadavpur area, plot number such and such, present Patuli station, okay, and have been residing there. In 2001, the Calcutta Municipal Coverage assessed property tax for 2001 amount in the name of said Brojagopal Saha. Brojagopal Saha is the original, is the
Father. See the paragraph 8.
That in the meantime, Brojagopal Saha died in and 2 daughters.
Shankar Saha, Subhash Chandra Saha, and Sri Ajoy Saha. Why? Why only 3 men? We got no opportunity of hearing.
Where is the document?
Document mirror in the last page. At page mirror. 19 annexure P2. The indenture made this. Page mirror.
You are not claiming as legal heirs of Brajagopal Saha.
Why not? I am a legal right. I am a legal claimant.
No, but the property was not
Yes.
allotted to Brajagopal Saha during his lifetime.
Yes. After
During his lifetime, property was not allotted to Brajagopal Saha. Now the governor, as per the administrative action, allotted the property in favor of one of the sons or two of the sons. Okay, 3, 4, 5, some of the sons.
Yes.
Can the other heirs challenge that administrative action?
The property was in the municipal corporation or everywhere it is named as Brajagopal Saha.
Municipal corporation is not the
Yes,
has not allotted the land.
no.
Is not the authority.
But in the name of he is in possession from 1955.
Maybe.
Brajagopal.
Maybe.
Therefore, my lord, his name was.
So according to you, if he is in possession of from 1955, then a case of adverse possession, that is a absolutely a civil dispute. It is a matter of evidence to be taken by the civil court. Each court cannot.
This allotment should be bad. This allotment should be bad. He cannot. Governor cannot pick and choose to allot the property. It is under the.
How the heirs are coming here?
No.
How the heirs are coming here?
Which year, my lord?
Heirs of Brajagopal. All the heirs of Brajagopal.
Brajagopal is in occupation and possession of the property. Refugee property, my lord.
Yes.
Now, after his death,
you were possessing the property either as a trespasser or as a forcible occupier. What is the Brajagopal status? Brajagopal status was either trespasser or a forceful occupier.
Forceful occupier.
So forceful occupier. Forceful occupier has got no ownership, no title. His title can be perfected only if he proved adverse possession against the government.
But what happened? All the properties in the area was forceful possession by the refugee. They came from the East Bengal, and
I have every doubt as to whether this writ petition is maintainable. On the question of maintainability, I want to hear. এটাতে একে নোটিশ দিন।
Government already served me.
Maybe. By an order dated 2nd May 2023, a coordinate bench directed Mr. Lolit Mohan Mahata and Mr. Prashanto Bihari Mahata, who are in the panel of the state government, to represent the state respondents in the instant writ petition. Full stop. However, none of them are present
In spite of service.
in spite of service of
Writ
notice.
petition,
Service of notice.
allocation.
Please do not dictate.
No.
I have that ability to at least to pass an order. So, কি বললাম? In spite of service of notice. Full stop. Next paragraph. in view of such circumstances, comma, no, in view of such circumstances, having heard the learned advocate for the petitioner, this court is of the view that the state respondents are required to be heard in the instant writ petition. Full stop. Therefore, the learned government pleader is requested to appear personally in this matter on 11th July 2023. Full stop. The learned advocate for the petitioner is requested to serve a notice to the learned government pleader along with a server copy of the order for his information and compliance.
Affidavit of service.
আচ্ছা একদম উপরে affidavit of service be kept with the record.
And cost-rated is wrongly printed and lawyer's name also wrongly printed.
এই এখানে হ্যাঁ আমি দেখছি ওই দেখুন কেটে দেওয়া আছে উপরে সুপ্রভাত সাহাটা গুলো কেটে দেওয়া আছে
স্বপন
ওইখানে ওই
স্বপন
ইয়ের
সাহা।
নামটা হবে স্বপন কুমার সাহা হবে, ওটা একটু ঠিক করে দেবেন কালকে। হ্যাঁ এই রেকর্ডটা একটু ঠিক করে দেবেন। ওকে
My lord, item number 3, 4, 5, and 6. I am led by MD Sabir Ahmed, my lord. All the matter becomes infructuous.
Shamal Kumar Mukherjee.
all the matters become
Yes.
infructuous. 3, 4, 5, and 6. It is submitted on behalf of the petitioner
3, 4, 5, and
that the instant writ petition has become infructuous during the passage of time. Accordingly, the instant writ petition be dismissed being infructuous. এটা হচ্ছে 3, 4, 5, 6. Seven. Mr. Banerjee, you are appearing in item number 7.
Yes, my lord, for the
Practically, the file is lying with the air court. The peon has gone to bring that record, so I am passing it over. When you will be free from other court, at that time
I am always
no.
at 2
At
PM,
that,
at 2 PM another matter is fixed before lordship.
so at 2 PM I shall take up
I'll
the
come
matter.
back on 2 PM.
It's a motion within a few minutes. Oh, you are for the private respondent. Okay. At 2 PM I shall
As
take
well.
up the matter because the record is.
Doesn't matter, my lord.
Okay.
No problem.
Thank you.
Now the African now saying no in this way, their hand indicates like no problem, no problem.
Neil. Sir, am I wrong to ask this question because of the government, when a person is a forceful occupier or a trespasser in respect of the land since 1955,
He doesn't have a legal right. He
does
doesn't
not
have a
any
legal right over.
So if he does not have the legal right, his heirs cannot claim the legal right through him. So and subsequently the governor allotted the patta under Refugee Rehabilitation Act to one of them. Now, can the other heirs challenge? Because any challenge by the other heirs will come from the father until and unless the father proves his case under as owner as adverse possession.
Lord, I beg to submit this, my lord. The ultimate allotment granted by the governor in favor of one or two sons. My lord, the basis of this grant or allotment is the initial occupation, illegal occupation by Brojadulala. Therefore, my lord, it has really some connection with it. Otherwise, my lord, the governor could not have picked up one for the purpose of making an allotment. That person is claiming through somebody who is in illegal occupation. The government doesn't want to drive them away. Therefore, government is making an allotment, giving a patta. Therefore, this grant by the government is not to me, not to him, but to a particular person, my lord, who is claiming through somebody who is
that illegal occupier.
Possibly, my lord, others will also have a right. Possibly.
That is to be looked.
Because till then, Lord, nobody had any right. All 6 or 8 of them, sons and
Nobody
daughters,
had any
nobody had any right. Then why pick up 1 or 2 for the purpose of conferring right?
Yes, sir.
Now, my lord, in this matter, I appear for respondent number 5 and 6 still authoritative interlimited. My lord, in respect of a land acquisition, which had taken place, my lord, during 80s.
Who is for the petitioner?
The petitioners, my lord, I just tell your lordship, your lordship will understand immediately why they are not appearing. My lord, the land acquisition of 85 or 86, my lord, that ended.
You are appearing on
for the still authoritative interlimited, for who are the requiring body. For my purpose, land was acquired by the state of West Bengal. I had paid, my lord, the land amount, the amount fixed by the state government. To the state government, I have paid all the compensation to the land losers. I have also paid, my lord, additional compensation on the basis of orders made in the reference cases. Everything is done. Now they claim that they should be given employment. They or their son or their grandson should be given employment.
Is there any scheme?
Yes, there was a scheme. That scheme, in regard to public enterprises, that scheme was abolished on 3rd February 1986. That scheme was abolished as far back as in 3rd February 1986. Therefore, after that, there is no scheme. So far as public enterprises is concerned, in my affidavit in opposition, my lord, I have included that particular document by which, my lord, that earlier scheme was abolished. Now, my lord, this matter is not res integra. My lord, this had appeared in so many litigations where courts have passed orders for the purpose of giving appointment to land users. Ultimately, when the matter went up to Supreme Court, the Supreme Court noticed that this document of cancellation of the
3rd February 86.
scheme, 3rd February 86, that document had never been placed before the court. And Supreme Court specifically noted that had such document been placed before the court, so many litigations would not have followed. Or, of course, in that judgment, the persons who were already selected by then pursuant to the trial court's order, Supreme Court did not touch them. But no further employment henceforth in respect of land users. That judgment, my lord, on the last occasion, I told your lordship that there is a judgment like that. I had handed up a copy of that judgment to my learned friend also. That 3rd February 86 is already in my affidavit in opposition. I have handed over the copy of the judgment also. Now, since then, they are not appearing. Because, my lord, they have nothing to say now.
Where is that judgment?
SCC 2014 SCC online. দিয়ে দে আছে আকারে আর আটেরটা আমার কাছে কোথায় My lord, I first take your lordship through the 3rd February 86.
Yes.
That is in my affidavit in opposition.
Affidavit in opposition to the
Affirmed by Shubhomoy Sarkar.
affidavit in opposition. But though in 1986 that order was passed, but in 16th May 2013, 178 candidates.
170 candidates. Milord, the situation was this. There was a temple inside the plant, Milord, where an extension process was going on on the basis of acquired land. There, Milord, extension project was to come up. But because of the existence of that temple, Milord, all of people
Local
of the
people,
area were
yes.
in order, Milord, to ensure that the extension work does not suffer, the government of West Bengal came forward and asked us not to come to some sort of a solution. The government sent up names of 178 persons who were not even eligible to be employed. The government requested the Steel Authority, State of West Bengal, requested the State Authority, the Steel Authority, to train them up, and for them, the Indian Institute of Technology was also requested by the state government to provide to provide accommodation, training facilities. That was given to them. Training was given to them, and then they was taken in the service. This was at one time
arrangement. Only to get
only
rid
to
of that temple.
Yes, only to get rid of that agitation, which was hampering
Yes, the extension procedure. So far as I remember, their case on the last occasion was that amongst the petitioner, practically amongst the petitioners, some names did appear in the list of 178 persons.
No. Well, all the 178 were taken in.
Okay.
They said that we stand in the same footing because their land was acquired, our land was acquired. That was their stand. Milord, if your lordship kindly takes up my affidavit in opposition, page 11. That is their only case, Milord. Article 14, that we stand in the same position as others who were given employment, this 178. Why not to us? That's their only case. Milord, if your lordship kindly takes up my affidavit in opposition, which is affirmed by Shubhomaya Sarkar, kindly come to page 11 of that affidavit, where
Page 11 is a notification dated 6th December 1979.
No, that was the previous one, because the names and the number and dates are given at the bottom of the notification.
At page,
kindly see page 13. At the bottom of
3rd February 1986.
the number and the dates are given at the bottom of each notification. Now, Milord, kindly take the subject is land acquisition and rehabilitation aspects involved in major projects. Now, Milord, kindly turn over. Paragraph 3, compensation. Paragraph 4, rehabilitation. Then, Milord, 13.
Yes. Page 13.
Page 13, paragraph Roman 4.
Roman 4.
The project authority should be directed to examine the list of awardee families eligible for rehabilitation assistance received from the rehabilitation cell with reference to their educational attainments and arrange for imparting to them suitable education and training to equip them to be considered for employment in the project subject to availability of vacancies. Such education and training should be imparted through the existing and available training institutions of the state and central government. The project authorities may meet the cost of training of the persons who are selected from amongst the evictee families. If suitable disciplines or faculties required for the needs of the public sector undertakings are not available with the existing training institutions, the project authority should undertake to fund and start such training courses which will equip candidates for employment in the public sector undertaking. Such training given at the cost of public sector undertaking should not be presumed to be a commitment for ultimate employment in the undertaking concerned. The main idea is to enable some members of the evictee families to qualify themselves for employment and compete for the same along with others. Then the next paragraph, 5. In the context of the urgent necessity of public sector enterprises operating at commercially viable levels, and generating adequate internal resources, overmanning has to be guarded against. Any understanding, formal or informal, in regard to offer of employment to one member of every dispossessed family in the project will stand withdrawn. However, with a view to encouraging the dispossessed families taking to useful avocations like poultry farming, animal husbandry, etc., the project authorities will assist the concerned state government in organizing and financing such activities. The basic responsibility of initiating such schemes will be that of the state government. I stop here. Therefore, we will have no employment. No employment, but financial assistance for the purpose of importing poultry, etc. And this
That is community development.
Yes, that is the 3rd February 1986. Now, my lord, I take your lordship through the judgment. This is 2014 SCC online.
Yes.
2014 SCC online, Jharkhand 1209. Now, my lord, paragraph 2, I read out one sentence only. The brief facts which are necessary for disposal of this case are that Bokaro Steel Plant, a national project of the Government of India, was commissioned. This is also under Steel Authority. Was commissioned and land was acquired from various landholders. I skip over. Kindly come to the next page. Paragraph 6 at the bottom. Paragraph 6 at the bottom. In the light of the contentions with the parties, the learned single judge in the order dated 18/4/2006 formulated 3 questions. Whether any scheme for appointment of land loser displaced person is existing. 2, whether the petitioners fall within the definition of the member of a family of displaced persons under the said scheme. And 3, whether the petitioners are otherwise eligible and entitled for appointments as per the said scheme. Now, the learned single judge held that the case of the respondents are to be considered in the light of the above 3 questions formulated, and the decision has to be communicated to the respondents. The said order of the learned single judge is under challenge in the present latest patent appeal. We have heard Mr. Anand Sen, learned counsel for the appellants, and Mr. Parthasarathi Ghosh, learned counsel for the respondents. Mr. Anand Sen, learned counsel for the appellants, has drawn our attention to the judgment of the Honorable Supreme Court in Civil Appeal number so and so of 2008, dated 5/3/2008. I shall hand over this judgment also. In the said appeal, before the Honorable Supreme Court, the orders passed in the contempt petition were under challenge. Referring to the memorandum of the government dated 3/2/86.
This memorandum.
Yes, Lordship. In which the scheme of offer of employment to one member of every dispossessed family in the project, the Honorable Supreme Court in para 9 to 12 held as follows. This is in 2008 judgment is being quoted, 3 paragraphs. Paragraph 9. Quote, we have heard learned counsel for the parties. The learned counsel for the appellant has invited our attention to subsequent memorandum of the government dated 3/2/1986, in which it was clearly mentioned in subpara 5 or para 4 as under. In the context of the urgent necessity of public sector enterprises operating at commercially viable levels and generating adequate internal resources, overmanning has to be guarded against. Any understanding, formal or informal, in regard to offer of employment to one member of every dispossessed family in the project will stand withdrawn. This is not what I have read out from that memo. Now, in the paragraph 10, it is unfortunate that despite the scheme having been withdrawn way back in 1986, the same finds no mention in any of the litigation which has arisen with regard to the project. If the decision to withdraw the scheme was already taken by the Government of India in 1986, then that should have been brought to the notice of the courts at an appropriate time, that whatever scheme that had to be implemented had in fact been already implemented, and henceforth no further employment would be given in terms of the scheme to such landless people whose lands had been acquired. Had this fact been brought to the notice of the courts by the parties, perhaps things would have been different. But unfortunately, this basic fact has been lost sight of, and this has resulted in a large number of litigation, and the present contempt petition before the High Court are an outcome of this. Be that as it may, it is now high time to put an end to the litigation. It is an admitted fact that the project was completed way back in 1966, and even after more than 40 years of the completion of the project, people whose land was acquired for the purpose of the project are still litigating for getting employment. This is not at all warranted. At the relevant time, the intention of the government was to rehabilitate the landless people whose lands had been acquired and to provide employment to one member of the displaced family so that they could maintain the family so displaced. It was not at all the intention of the government to distribute this kind of largesse on an indefinite basis. This is nothing but an abuse of the process of the court. However, to put an end to the controversy at hand, we direct that the 970 persons whose names have been included in category 2 as per order dated 7/4/98 of the High Court will be considered for appointment, other things being equal. It is submitted by counsel for the appellant that in the advertisement dated 1/6/2007 for 300 general vacancy, it has been mentioned that preference will be given to those displaced persons whose lands had been acquired. The relevant portion has been written reads as under. Then paragraph 10. In the light of the memorandum of the government dated 3/2/1986, withdrawing the scheme of offer of employment to one member of each dispossessed family in the project, the Honorable Supreme Court categorically held that it was not the intention of the government to distribute this kind of largesse on an indefinite basis, which is nothing but an abuse of the process of the court. In view of the above judgment of the Honorable Supreme Court, the direction of the learned single judge to consider the case of the respondents cannot be sustained and liable to be satisfied. This is the paragraph. This paragraph 10 is of the judgment of the Honorable Jharkhand High Court. But this is based on the Supreme Court judgment of 2008.
Yes.
Where I can hand up this 2008 judgment also, but it is quoted here.
Yes, everything.
Yes,
Entire
paragraph
matter
9
is
to
quoted.
12 is quoted. Therefore, on the basis of this, petitioners do not have any case. There are 117 petitioners here.
Achha, their land was acquired in the year 2006.
Milord,
Yes, by LKS number such and such.
yes.
8889.
That temple is Jhodoburi. Jhodoburi. I have mentioned in paragraph 6 of my affidavit.
Yes, I can. I do not know whether I am right or wrong. While sitting in civil appellate jurisdiction, second appeal, most probably I dealt with this this thing. That villagers are now claiming that the temple site is to be de-requisitioned and is to be handed over to the villagers. So
That there was civil
some
proceeding on
judgments are there. Yes, a civil suit was declaratory suit was filed. Initially, it was most probably initially it was decreed. Thereafter, in appeal, it was dismissed, and then second appeal. So second appeal, I dealt with that matter. Most probably I
Because Jhodoburi, that is that
yes,
name.
yes. Jhodoburi temple, probably I dealt with the matter. Yes. Though the petitioners are not represented, this court is of the view that the instant writ petition can be disposed of on the basis of the submission made by the learned senior counsel on behalf of respondents number
5 and 6.
Respondents number 5 and 6. Full stop. Next paragraph. Indisputably, the Indian Iron and Steel Company, within bracket IISCO, a subsidiary concern of the Steel Authority of Limited,
Steel Authority of India.
Steel Authority of India Limited, acquired a large chunk of land
My lord,
on the basis.
ISCO did not acquire. State of West Bengal acquired for it.
Oh, of course. কি বললাম? Acquired না. Handed over. Yes, you are for the petitioner. So what is your submission? You tell me.
Last occasion that when judgment was referred by
Hmm.
senior friend that,
Yes.
but which is in fact in my favor.
3286 judgment. Sorry, 2014 SCC online judgment.
2008.
2008 judgment of the Supreme Court.
Yes.
Yes.
Supreme Court এটা তো? ঠিক আছে।
Yes.
হ্যাঁ।
2008 SCC online.
ফাইলটা দাও। আচ্ছা, আমার মার্ক করা আছে। আমার মার্ক করে জাজমেন্টটা দাও। এটা তো?
আমি ঝাড়খণ্ডটা লিখেছিলাম তারপর
না, ঠিক আছে। আমি প্লেসিং দ্য সুপ্রিম কোর্ট জাজমেন্ট ফার্স্ট। সুপ্রিম কোর্ট জাজমেন্ট।
Yes.
Because while I was submitting last occasion, there is a clear case of discrimination. This was my case. That admittedly, from their affidavits and undisputed records, that 178 landlords have been given appointment. And according to the cell, this list was prepared by the state, and the state has provided this list to the cell. So last occasion, my submission was, what was the basis based on which this list was prepared and our names has been excluded from that list.
Yes.
আমাদের reply টা বার করে select list. Namlet, there was no rational basis for such discrimination.
Yes.
In fact, all the land users forms it's a single class. They are part of a single class. And this was my submission on the last occasion, and at that point of time, my senior friend made submission that there is a judgment of the Supreme Court, and he has handed over this. That after this, there cannot be any further argument on this because the issue has been decided by the Honorable Supreme Court. Namlat kindly takes up the judgment that was cited by my land friend, in fact.
Yes.
I'm just reading the relevant part, paragraph 7. So far, the list of category 2 is concerned, the DPLR gave a list of 970 person because the list of category number 1 had already been exhausted, and all the person whose names were forwarded by the DPLR were given employment except those who were found to be medically unfit, unsuitable, ineligible. Then, on 1st June 2007, the appellant advertised for 300 general vacancies in the company, and the same were filled up after due selection process. And the 26 persons who moved for contempt were also selected in the process, in the said process, other things being equal.
Yes.
Again, the appellant came to see that despite having already exhausted the list of category 1 and also having appointed 26 persons from the category 2, they are again under the threat of contempt. This is the genesis of this litigation. Although they are under no obligation to give employment to the person placed in category 2, as the orders of High Court dated April 7, 1998, they were only required to be considered for employment. To be considered for employment. That was the consideration. We have heard the learned counsel of the parties. Learned counsel of the appellants has invited our attention to the subsequent memorandum. This is important, right? Of the government dated 3rd February 1986, in which it was clearly mentioned in subpara 5 or para 4 in the context of the urgent necessity of the public sector enterprises operating at commercially viable levels and generating adequate internal resources. Overmanning has to be guarded against, and any understanding, formal or informal, in regard to offer of employment to one member of every dispossessed family in the project will stand withdrawn. This prompted the court to pass certain observation. It is unfortunate that despite the scheme having been withdrawn way back in 1986, the same finds no mention in any of the litigation which has arisen with regard to the project. If the decision to withdraw the scheme was already taken by the government of India in 1986, then that should have been brought to the notice of the court at appropriate time, that whatever scheme that had to be implemented had in fact been already implemented, and henceforth no further employment would be given in terms of the schemes to such landless people whose land has been acquired. Had this fact been brought to the notice of the court by the parties, perhaps things would have been different. But unfortunately, this basic fact has been lost sight of, and this has resulted in a large number of litigation, and the present contempt of petition before this court, High Court, are an outcome of this. Be that as it may, it is now high time to put an end to this litigation. Then the court proceeded, and in paragraph 14, court says, since they are equal in the result, we set aside the judgments also, the rule, contempt rule. We allow this appeal with the direction that 970 persons whose names are appearing in category 2 as per direction of the High Court shall be considered and given preference for employment, other things being equal. So far question of Article 14 is concerned, court has held in my favor. And court has cautioned, in fact, I may use this phrase, that the parties should have brought the fact that the scheme is no longer exist. That would have minimized the number of litigation. That was the concern expressed by the Honorable Supreme Court. Now, in my case, if your Lordship kindly takes up my petition. Entire things were being done without informing anyone. Now, in 2016, last occasion I have shown to your Lordship, just to refresh your Lordship's memory, kindly takes up page 383 of my writ petition. Nothing was in public domain. We at our own were making representation. We have also made application under Right to Information Act, and is in response thereto, by a letter dated July 6, 2015, yes, the sale has informed us, provided us with a list of persons who are whose name was forwarded by the state, and they have sent for training. And subsequently, in I have shown to Lordship last occasion also, Kindly see at page 410 then. And when they are taking this decision and when they are employing, these dates are relevant. Now let kindly see 410.
Yes.
That on 13 January 2016, these persons were being employed. These I have gathered from other sources.
Yes.
Now let kindly take some my affidavit in reply to their report. This is dated 27 June 2016.
June or
27th June 2016, if I'm not mistaken.
Or 25th June or 2016.
16. A form from 27 June 2016.
দেখুন ওইদিকে আছে।
দেখুন একটা কপি দেওয়া হয়েছিল 2016. But I have annexed.
Yes.
A minutes of page 6, relevant page 7.
Yes.
This is also at the instance of cell. This is ISCO.
Yes.
Page 7, paragraph 10. I believe it is legible. May I read?
The employment.
The employment will be offered to all the candidate initially as per company rule, and if any qualified
candidate exists,
his
case will be
considered as
against
in one vacancy. In one vacancy or in our no. This is not really legible, right?
In course of vacancy. It is not.
I'll try to type copy should have been given. And the page 6, very first paragraph.
Just 1 minute.
I'm sorry, extremely sorry. Type copy দেওয়া উচিত ছিল।
No, type copy is there at page 9.
Oh, I'm sorry.
In case of vacancy.
I'm sorry.
That is in case of vacancy.
Yes. I'm sorry.
Yes, in case of vacancy.
Oh,
yes, 10, page 9.
Very first paragraph, at page 8, this is to demonstrate that this is a case of land losers.
That is that was held on 26th October 1981. 1981.
81.
But your property was taken in the year 2016.
Yes. No, not 16. Acquisition was made prior to that too.
No, state government acquisition was made 2006.
Process was started in 2006.
Okay.
Now this is also independent to the scheme that has been withdrawn. Now this resolution that I'm showing this is in terms of company rules. এটা স্যার না এইটা নয় স্যার আমার একটা 27 জুনে
একটা রিপ্লাই একটা দুটো রিপ্লাই আছে এটা বলা যায় একটা নন দেওয়া
আচ্ছা আমি হ্যান্ড ওভার করে দিচ্ছি 27 জুন ওরা নিয়ে হ্যান্ড ওভার করে দিচ্ছি
yes
now This was done in terms of company's rule. There must be some decision of the company.
Yes.
Now let page 11. This is of 2013.
Yes.
Well, this is from the website of the Union Government. Third paragraph. Sri Verma said the amount pertaining to the compensation has been deposited with the state government as per demands raised from time to time. Recently in 2007, BSL has also deposited rupees 70 crores with the district judge, Bokaro, towards payment of enhanced compensation. In principle, it was agreed to provide employment to at least one member of displaced family initially. BSL has so far provided employment to more than 16,000 displaced persons, which is much more than the number of families originally displaced. Employment of displaced person at cell is now being regulated in terms of DPE guidelines and legal pronouncements. Now, therefore, what I'm trying to demonstrate from this press note, this is a press note which is available in the website of the Union Government, that even in 2007, they were considering employment in respect of the acquisition made in 2007. Even those person was given compensation, enhanced compensation even thereafter. Therefore, this is consistent stand of the Union Government as well as these companies, government companies, who are not providing employment. Now, I have twofold of grievance. First is against the state and second is against the company. And both are government undertaking. Companies government undertaking government company. Now, state has failed to demonstrate the rationale between the person who have been included in the list and the person excluded. The basis. There is no rational basis. We are similarly placed. Therefore, our name should have been there in the list of 117 candidates as provided by the state. And second, the immediately when the state provides those lists, it's the obligation of the company to consider our employment on priority basis. The plea that has been taken in the affidavit of the company that there is no vacancy, which is not correct. Vacancy may not be available on the particular time or date that they can apprise your lordship. But subsequently, I have taken out an application to demonstrate the post our application. The post in respect to his appointment has been given. I have shown the appointment letter. In those posts, again advertisement has been made. Application. Oh, sorry. The Ekusher converter. Application. Yes. Page 36.
Page 36
of my application.
What application?
This is application for appropriate. This heading is this can 1 of 2021.
Can 1 of 2021. Thank you. Yes.
Yes, just a second.
Page 36.
Yes, 36. I have given them the advertisement to show that the vacancy, just in respect of which the appointment has been the post in this. This is attendant cum technician trainee. Now, kindly take some page 37. But
yes.
This is attendant cum technician training.
Yes.
This post was advertised.
Yes.
Therefore, the plea that there is no vacancy is not correct. There is vacancy. They are inviting applications. Now, let there are posts, let therefore the vacancy will occur, but it may not be possible for them. And I'm thinking practically, let to engage all the writ petitioners together on a particular date, but they should be given preference.
At present, what is the age of those persons?
Yes, they are within the age limit.
28 years.
Yes, that their son employment from one member of the family. That was the consideration.
So they are the sons of the landlords.
Now, this petition has been filed by the landlords or their successors.
Okay.
Granddaughters, grandsons.
Okay.
Now, there are, I can provide the list of sons and daughters, not granddaughter and grandsons. Now, most of them are from the direct family members. Now, they should be considered for appointment.
Yes.
Whoever the dependent, they should be given appointment.
That's all.
I'm extremely sorry,
No, not at all. You have come at just a minute. কি বলছো?
ও স্যার, আমার এফিডেভিটটাই নিয়ে নিন, আমি আপনাদের আমাদের তো দাও নিতে পারি, আমি আপনার কাছে পরে আবার নিয়ে নেব। হ্যাঁ, এটাই আমি করছি। Since my line train has yet to start, only one thing I want to add. At present, that policy of landing has changed that, and there is a sea change in the acquisition process. Now, the present scheme also provides for employment. They may say this act has no retrospective effect. I don't say that, but the principle that is being followed from 1986, which was subsequently withdrawn, still being followed by the union government. Therefore, in principle, they have agreed to the proposal or the scheme of employment.
yes. Yes.
Milord, so far as this affidavit of 2016 is concerned, this was never served upon us. I find it mention of it for the first time today. Even on the last occasion, they wanted to rely on something. They said that we had filed some documents, some affidavits. Your Lordship directed in your Lordship's last order that those be served. Nothing was served even after that. This 2016, Lord, I see it for the first time. Regarding, Lord, this is Bokaro Steel Plant, some policy there.
Yes.
Bokaro Steel Plant. Here it says, Lord, the employment of displaced persons is being regulated in terms of DP guidelines and legal pronouncements.
Yes.
I had shown to your Lordships the DP guideline, Department of Public Enterprises. It was previously known as BPE.
You are showing page number
11 of this 2016.
11. Oh, that is press release.
That is press release.
Press
Uh,
release, press release.
This is handed over to me, my lord, for the first time
Yes.
now in court.
Yes.
It relates to me that Bokaro Steel Plant. It says that
In terms of the DP guideline and legal pronouncements.
yes, this is being followed. I had shown to your lordship the DPE guideline.
Yes.
It was previously known as BPE, Bureau of Public Enterprise. Now it is now they call it Directorate of Public Enterprises. Here, it records that in Bokaro, employment had been given, over employment, in fact. That is what it is recorded here. But the other affidavit, other application, my lord, which I also find today only. There, my lord, I find a 2018 advertisement regarding employment. The last date was in some month in 2018. Did they apply? Pursuant to this, where is that apartment that they applied for this?
Yes.
There is no application, at least no pleading with regard to that. Therefore, my lord, the company cannot consider anybody and everybody non-applicants. The question doesn't arise. My lord, if they have the required qualification as per this advertisement, they are entitled. My lord, without being qualified, they cannot be given preference. They have to compete with them on the basis of their qualification. Then they get a preference. Even if I accept, my lord, the press note to be the correct thing.
Yes.
Then also, my lord, they have to qualify, and then only they will be given preference as per this press note. But here, my lord, at this advertisement of 2018, if your lordship sees the last page at page 42, it mentions that the starting date for submitting applications through website and the closing date is 4th of December 2018. Closing date.
Yes.
4th of December 2018.
Yes.
সেখানে কি বলা আছে? It mentions, in different disciplines, fitter, mechanical, different posts with different qualifications required.
Mr. Ahmed only pointed out that attendant come technician. With regard to other posts, he has no submission.
It cannot be his choice.
Yes.
He has to fulfill the qualification.
Yes.
But where from do I get, my lord, that his clients, this one
Qualified and filed the
117%.
application.
Yes. Who are the petitioners? Kindly see, my lord, for whom the employment is being sought. That your lordship will kindly find, my lord, from the writ petition. Kindly take page 31.
Of the writ petition.
Of the writ petition.
Yes.
Page 31, my lord, the list of entire writ petitioners is given, who asks for employment for number 1 for his son.
Yes.
Next is
Daughter.
Then son, then daughter-in-law.
Yes.
Then self, page 33, top self, then son, again son, then kindly take, my lord,
35.
page
35. Daughter-in-law.
Page 35, daughter-in-law, then page
13, serial number 13 at page 35.
Yes. And
Daughter-in-law.
page 36,
Grandson.
serial number 15, grandson.
Yes.
And then, my lord, daughter, son. Then again, serial number 23,
38 grandson.
yes, 38 grandson. Then, my lord, next,
Serial number 25 granddaughter.
24 also granddaughter.
24 granddaughter.
Then 42, page 42, serial number 35,
Granddaughter,
granddaughter, then grandson. Then son, daughter, page 44, nephew. Serial number 45 at 45, grandson. Page 45, serial number 45, grandson.
46 daughter-in-law.
Daughter-in-law. Then 55, serial number 55, grandson.
grandson. Sixty-four grandson, serial number.
Like that, not this.
Yes,
So granddaughter, nephew.
70 grandson.
I find nephew, several
Grandson.
nephews also.
77 son. Granddaughter, nephew.
Then 77 and 80 nephew.
78 granddaughter.
Like that. But the question is, Milord, even if any preference is to be given, that has to be made on the basis of the application made pursuant to employment notification. Milord, where is the pleading here? Milord, my first case, Milord, as I submitted that BP guide, the BP notification of 3/2/1986, which Milord withdrew this position. The press note, I see it for the first time here, Milord, I have to check it up whether it relates to all the steel plants or not. This refers to only Bokaro. I do not know whether it applies to our East Coast steel plant also. In any event, even if I take it that it does apply, I have to take instruction on that. Even if it applies, one has to make an application in order to get preference.
Yes.
Milord, without making an application, simply they have no right to get employment straight away. That is not the case made out either.
Yes.
That just because my land was acquired, I am entitled to employment. That is not the case.
Yes.
And this press release is of 2013. I do not know whether after 1986, during the relevant period in 2006, what was the position guide? What was the BPE guideline then?
Okay.
This is 2013. Maybe it is reintroduced. Between 86 and 2013, maybe it is reintroduced later on. But what was the position at the relevant time in 2006 when this land was acquired? I'll have to take instruction
the landlosers or their near relatives
Your
whose-
family members come, kindly use that.
or their family members
Family member is defined, who comes within that.
and or their family members with a prayer for appointment in different steel plants under the administrative control of the Steel Authority of India Limited. Full stop. Next paragraph. Let me now briefly narrate the facts of the case. For development and subparagraph kore, for development and enhancement of ISCO steel plant
Expansion.
Development and expansion of ISCO steel plant some land was required. Full stop. The state government in acquisition process VDLA case number LA-11/32R/88-89 R, capital R, /88/89 acquired considerable portion of land in the moujas of Nakra Shota, NAKRA SOTA, Kuilapur, Borodighari, Hirapur, Sharmara, and Purushottampur within PS. Within PS, what is the PS? Do you know? Or in the district of West Bardhaman, I should write. PS jail number that is required, or within the district of West Bardhaman. I should record that.
JL 19.
Huh?
JL 19.
JL 19 cannot comprise of all the villages.
PS Hirapur.
All villages within PS Hirapur, West Bardhaman.
At 11.0 it was part 1.
Okay. The undivided Bardhaman. Full stop. The area of the land acquisition was measuring about 308 acres. The said land was handed over to ISCO for expansion of the plant. Next paragraph. Subsequently, no, this subsequently, within the said land, there was a temple comma called by local people as Joriburi temple. এটা কোটেশনের মধ্যে ঝোরি ঝোড়বুড়ি ঝোড়বুড়ি টেম্পল। আচ্ছা, the a dispute cropped up between the steel plant authority and local villagers on the issue of shifting the said temple. Subsequently, the landlords and local people started agitation for employment in addition to the compensation granted by the ISCO to the landlords in accordance with law. Full stop. ISCO prepared a list of 178 numbers of people, numbers of candidates being the landlords or their relatives and sent it to the state government for verification. After getting the verification report, the ISCO made arrangement for their training and on receiving training successfully, they were absorbed in the establishment of ISCO. Next paragraph. It is the case of the petitioners that they are also similarly placed persons and they have been discriminated by not offering the job by ISCO and the said authority being an instrumentality of the central government violated the right to equality enshrined in Article 14 of the Constitution of India. Full stop. The learned advocate, next paragraph, the learned advocate for the petitioners at the outset takes me to the to an offer of appointment for the post of attendant cum technician within bracket trainee given to one Miss Shumona Ghosh within bracket Roy on 13th January 2016. It is submitted by Mr. Ahmed, the learned advocate for the petitioners, that immediately after issuance of the said appointment letter, 2178 land losers, the petitioners being similarly placed has filed the instant writ petition. Full stop. It is the learned advocate for the petitioners also refers to a letter dated also refers to a letter dated 16th May 2013 written by the Deputy General Manager, personnel, PERS within bracket, sale to one Ashish Majhi, one of the petitioners herein, stating inter alia that based on the list of names of villagers whose lands have been acquired for ISP, provided by the government of West Bengal, ISP under its CSR initiatives has undertaken the training of 178 land losers through government's ITIs under craftsman training scheme within bracket CTS to make them employable for the purpose of earning their livelihood. Full stop. It is contended by Mr. Ahmed that the said letter when the said letter was issued, the petitioners came to know that 178 landlosers were given training in ITIs run by the state government to make them employable. It is also submitted by Mr. Ahmed, referring to a letter dated 6th July 2015, which is an information upon an application under the RTI Act that the petitioners came to know the details of the landlosers and their relatives who received employment by now. In the establishment of ISCO, full stop. Thus, it is contended by Mr. Ahmed that the petitioners being similarly placed and are entitled to similar treatment by the state authority and they have approached this court at the earliest opportunity immediately after receiving the information that 178 candidates, 178 landlosers or their relatives are were given training to make them employable in ISCO. Full stop. I am coming just after 5 minutes. Mr. Gupta, comma, learned senior counsel on behalf of respondent numbers 5 and 6, na? But affidavit in opposition is filed on behalf of respondent number 4, 5, and 6. So respondent numbers 4, 5, and 6, comma, on the other hand, submits that the scheme of providing employment to the land losers in addition to payment of compensation has been abolished way back on 3rd February 1986. Vide BPE OM number 15/13/84 dash BPE within bracket C dated 3rd February 1986. Mr. Gupta specifically refers to clauses 4 and 5 of Rule 4 of the said OM, which deals with the issue of rehabilitation of the land losers. Clauses 4 and 5 are reproduced below. এটা হচ্ছে page 13, 4 and 5 of affidavit in opposition on behalf of the respondent numbers 4, 5, and 6. Thus, it is clear from clause 5 that the liability of providing employment to the land losers or their relatives causes overmanning of the public sector enterprises. Therefore, the public sector enterprises which was to be guarded against. Full stop. Thus, it is held that any understanding, formal or informal, in regard to offer of employment to one member of every dispossessed family in the project will stand withdrawn. The said order also provided alternative provision stating inter alia that with a view to encouraging the dispossessed family taking to useful avocations like poultry farming, animal husbandry, etc., the project authorities will assist the concerned state governments in organizing and financing such activities. Thus, the offer of employment to one member of every dispossessed family in the project stood withdrawn with effect from 3rd February 1986. It is also contended by Mr. Gupta that the aforesaid office memorandum was not placed before any court previously, which resulted in issuing writ of mandamus commanding the respondents to offer employment to the members of every dispossessed family, or in other words, landlosers and their relatives. Had it been placed beforehand, there might not have been similar type of litigations piled up in the courts of the country. Full stop. It is Mr. Gupta. Now, in support of his contention, Mr. Gupta refers to a division bench decision of Jharkhand High Court reported in 2014 SCC online Jhar JHAR 1209 a colon দিয়ে Steel Authority of India Limited and others versus Rotiram Majhi and others. The factual circumstances narrated in paragraph 2 of the said of the aforesaid report recorded the facts of the case which are almost similar to the facts involved in the instant case. Next paragraph. The division bench of this division bench of Jharkhand High Court relied on the decision of the Honorable Supreme Court in Civil Appeal number 1774 of 2008, decided on 5th March 2008, colon দিয়ে, Steel Authority of India Limited versus Debilal Mahato and others. Paragraph 9 to 12 of Debilal Mahato and other, Debi hoche DEBY কিন্তু এখানে, Debilal Mahato and others within bracket supra are relevant and recorded as hereunder, colon dash record 9 to 12. Therefore, next paragraph. Therefore, in the light of the memorandum of the government dated 3rd February 1986, withdrawing the scheme of offer of employment to one member of every dispossessed family in the project, the Honorable Supreme Court categorically held that it was not the intention of the government to describe this kind of largesse on an indefinite basis, which is nothing but an abuse of the process of court. Full stop. In view of the above relying on the said judgment, the division bench of Jharkhand High Court allowed the writ petition and allowed the appeal filed by the Steel Authority of India Limited, setting aside the judgment of the Honorable Single Judge. Full stop. Next paragraph. Mr. Ahmed comma, in reply, comma, submits that if the decision of the Honorable Supreme Court in Debilal Mahato be read with reference to the fact of the said case, comma, the ratio laid down in the said report supports the petitioners. Full stop. In this regard, he refers to paragraph 5 of the said judgment. The Honorable Supreme Court was pleased to record that as per the direction given by the High Court, comma, 2 lists of displaced persons were prepared. Full stop. Category 1I, category I list consisted of persons whose lands along with buildings were acquired, and category II list consisted of persons whose lands alone were acquired. Full stop. Paragraph 7 of the said judgment states that so far as the list of category II is concerned, comma, the DPLR gave a list of 970 persons because the list of category I had already been exhausted, and all the persons whose names were forwarded by the DPLR were given employment except those who are found to be medically unfit, unsuitable, and ineligible. Then on 1st June 2007, the appellant advertised for 300 general vacancies in the company, and the same were filled up after due selection process, and the 26 persons who moved for contempt were also selected in the said process, other things being equal. Full stop. Then Mr. Ahmed takes me to paragraph 14 of the said report, which is the conclusion and ordering portion of the said report delivered by the Honorable Supreme Court. Paragraph 14 runs thus, colon dash 14. In the result, we set aside the judgment and order dated 3/10, 3/10, full stop 01, full stop 2007, passed by the division bench of the High Court, and dismiss the contempt proceedings pending before it, full stop. We allow this appeal with the direction that 970 persons whose names appear in category II, as per the direction of the High Court 7/4/1998, shall be considered and given preference for employment, comma, other things being equal. Achha. Next paragraph. Thus, it is submitted by Mr. Ahmed that the Honorable Supreme Court never held that the said 970 persons whose names for employment were not considered would not be at all considered by the appellants. On the other hand, direction was issued in respect of the said 970 persons for being considered and given preference for employment by the appellant. Full stop. Next paragraph. It is also submitted by Mr. Ahmed that the process of employment given to 178 candidates was done without informing all the landlords or their relatives who were also eligible for employment at the relevant point of time. The state names were verified and forwarded by the state government. At the time of forwarding the names of 178 candidates, the state government did not mention that there were other similarly placed landlords or their relatives who are also entitled to be employed. Thus, the state government failed to demonstrate the rationale of inclusion of only 178 candidates for employment and omission of the other eligible candidates. The respondent numbers 4, 5, and 6 had also the obligation to consider the case of all the land losers relating to their claim of employment It is also submitted by Mr. Ahmed that a scheme cannot be implemented in a piecemeal manner. Full stop. Next paragraph, in order to demonstrate the in order to demonstrate the issue that the OM dated 3/2/1986 was not considered even subsequently by respondent number 4, 5, and 6. The learned advocate for the petitioners refers to the meetings of the minute the minutes of the meeting, refers to the minutes of the meeting dated 26th October 1981, wherein it was held in point number 10 that the employment will be offered to all candidates initially as per company's rule, and if any qualified candidate exists, his case will be considered in case of vacancy. Full stop. This relates to the plant of ISCO at Bokaro. Full stop.
Not ISCO.
ISCO Bokaro. ISCO Bokaro. Full stop. He also refers to a press release issued by the Ministry of Steel, Government of India, dated 18th March 2013. In the said press release, in the said information, it was disclosed by the Ministry of Steel, Government of India, that in principle, it was agreed to provide employment to at least one member of the displaced family initially. Full stop. BSL মানে হচ্ছে It is means Bokaro Steel Plant. BSL within bracket করে দিন Bokaro Steel Plant has so far provided employment to more than 16,000 displaced persons, which is much more than the number of families originally displaced. Employment of displaced persons at SAIL / BSL is now being regulated in terms of the DPE guideline and legal pronouncements. Full stop. Acha. Next paragraph. Mr. Ahmed also takes me to an application being CAN 1 of 2021 filed in the instant writ petition by the petitioners praying for appropriate order and refers to Annexer C of at page 36 of the said application, being the recruitment advertisement in SAIL-ISP, Burnpur, dated, what is the date, Mr. Ahmed? Dated 15th November 2018. Full stop. In the said advertisement, comma, vacancy in the vacancy to the post of attendant cum technician within bracket trainee was declared with eligibility criteria in respect of upper age limit stated to be 28 years. Full stop. Therefore, according to the learned advocate for the petitioners, the petitioners were entitled to be considered for employment in the vacant posts of attendant cum technicians. Rest I shall dictate after recess. Okay. After recess, I shall take up take up group 8 matters, and then at the end I shall dictate.
Fix matter.
Huh?
My junior will be there.
Next. Yes, no problem. Anybody, or you will find the judgment at least
Huh? কোনটা? হ্যাঁ।
Well, in this matter, I am appearing for the private respondent. And I am appearing for the private respondent number 8, 9, and 10. And I am filing the vocal account.
ভোকালতম in the department.
All right.
তোমার ব্যান্ড কোড কিছু ব্যান্ডের নেই
In person.
ইন পার্সন
I already made a party.
Okay. What's the matter about?
But this is the case where my client is here to have a justice. Of course, my lord, whoever come and knock the door of the temple of justice, he always says, I'm here for justice. So certainly my lord will ask me what injustice has been done. And there is a gross injustice and irregularity on the part of the authority. Now, let me just explain in short the background of this case, my lord. The father was holding a license of MR dealer. Now, my lord, in list of dates I've just incorporated. Now, here's so, my lord, he also claimed. So the question is, my lord, who is actually eligible? And to consider that, naturally, my lord, authority must apply his mind properly, thoroughly, and proper investigations. But this is not for the first time. The lease has come before us, my lord. Earlier, writ petition was moved, then remand, then further hearing, then in this way it is going on. Now, I just draw your logical additions one judge order of Justice Talukdar Azil Ositen was just yesterday as retired. Today I am calling me as Azil Ositen was. Well, that is a page. Which is very relevant. I'm being happy. 113. দেখেছিস তো ঠিক
Yes.
এই পেজের সঙ্গে মিলবে তো
Yes.
89 ভালো করে বল যার সঙ্গে মিসলিড করিস না Yes, kindly take trouble to come page at 89. Have you also got it, my lord? Page 89.
Yes.
With your losses, kindly leave. I am placing, my lord. Parties are represented in the order. Their names are such. Mr. Kollan Kumar Bandyopadhyay, learned senior counsel, appeared for the appellant and submit at length. Mr. Somiran Mondal, my junior friend, learned counsel, appeared for the private respondent. Mr. Sengupta, learned senior government advocate, appears for the state with Mrs. Dubey, learned advocate. At issue in this appeal, in the grant of fair price shop license held by the deceased father of both the appellant and the appellant number 1, the Honorable Single Bench directed the subdivisional controller, food and supply, the respondent number 6, to this appeal, Khadra, such and such district, Bankura, a specified period of time, permitting the parties to submit requisite document in support of their respective claim to the FCA. At this stage, after hearing the parties and considering the materials placed, this court keeps the matter for further adjudication and restrain the respondent from declaring the vacancy in questions and from taking any step to fill up the said vacancy until further order. This court, Kali marked it 111. This court is also prima facie of the view that the issue of gainful employment of either of the parties, that is appellant and the private respondent, 1, this appeal existing at the time of applying for grant of FCA dealership was a material consideration before this honorable bench. Then the subdivisional controller, have you got it, my lord?
Yes. Yes.
The subdivisional controller, food and supplies department, Khatra, District Bankura, the Resolution 6, is therefore directed to file a report to London State Council on the next day as to the status of the nature of the gainful employment, respectively of the appellant and the private respondent at the point of time of such and such. The report of the Resolution 6 is expected on the next day. Let the matter appear so. The report was sought for by this authority. Then, my lord, kindly see, my lord, the page at the to the outer page 93. 93, my lord. Have you also got it, my lord? Page 93.
Yes.
In compliance of the directions of the Honorable High Court, Calcutta, in the above case about employment status of the appellant Ajit Kumar Das and the respondent was this Ajit Kumar Das is another brother. He is also claimant. Thus, the undersigned hereby files the report from the available record in the observer. Satish Chandra Das was a such. Shiv Shankar Das filed an application for grant of license of the compliance count number 21. At the time of said application, 21st, Shiv Shankar Das was holding a SKO retail license in his name, being number such, which indicates that he was employed at the time of making application for grant of such and such and such. It appears that Satish Chandra Das, during his lifetime, made an application for transfer of the dealership in favor of Ajit Kumar Das, along with his application by Ajit Kumar Das Form C, Tier Chalan, amounting to 2,000 on account of such application fee and inquiry. In respect of said application was made by the area inspector and the inquiry report. The status of Ajit Kumar Das was recorded as unemployed. Kali marked it, my lord. It is very relevant. Unemployed. However, before consideration of this application, Satish Chandra Das died and the said application became infructuous. So the facts, Kali pause here for a moment, my lord. From his own report, it appears that what was done by his father, it has no value. It has lost its force. It has gone in the wind. After the date of Satish Kumar Das, Ajit Kumar Das made an application on 17th May 2017, but did not attend the tier challan, attach the tier challan in escaped application fees. However, tier challan was submitted on 29th May 2017. So that was a mandatory provision. He must file that along with the application. That was not done. It is recorded. The phrase application of Ajit Kumar Das could not be considered because application fee was not deposited after 60 days period. Moreover, Ajit Kumar Das could not obtain no objections from other legal heirs and such. This is no other record in office to ensure the employment status of Ajit Kumar Das at the time of application of transfer and compulsory if it is submitted through the London at Consular Complete. Now, my lord, kindly come to page 94, my lord. It's very relevant.
Yes.
My lord, after that, my lord, an order was passed by the Honorable High Court. You have to put that. My lord, court directed, you can take exception of the report. Page 94 is very relevant.
After that, what is the final judgment of the appellate court?
I am coming, my lord. Our grievance is this, my lord, that when the court directed us, that, well, you can take exception of the report.
Yes.
And that was fine. By both the parties, not that.
Yes.
I'm just drawing logical attention regarding that particular report, which is very relevant.
Yes.
Shiv Shankar Das, Son of Censor, that I am the writ petitioner, Sansa Novara in the not relevant. Then, that by an order did a Sansa Honorable Division Bench presided over by Honorable Justice Suputo Talukdar and the Honorable Justice Krishna Rao was of the prima facie view that the issue of gainful employment, which has already placed, my lord, such Karta District Bankura State Council and such dealership, that in compliance with the orders that are passed by this Honorable Court, a report has been filed about the employment status of the appellant and the respondent one, whereupon it appears that I was holding kerosene oil such and such in my name, being licensed and such, that I was employed at the time of making application for grant of fair price of development on such and such in place of my deceased father, who is such status and such. That in the said status report, as filed with 6, the subdivisional court of food supply district did not at all consider the gainful employment of either of the parties at the point of time when both were the applicant for grant of fair price of dealership. The said response has only made a table inquiry and without conducting any field inquiry, submitted the status report of wrongful employment in respect of myself only. He did not even verify the status of kerosene license has granted in my favor about the actual weekly allotment of kerosene oil made to me, wherein I was allotted only 95 liter to 224 liter kerosene oil weekly for distribution, which was more like a social work rather than gainful employment. And as such, I surrendered the said license on 24 January 2018 and running a mobile teacher shop as well as STD booth. Photocopy of the said. Nothing, everything is disclosed, nothing suppressed. Then, that on the other hand, the appellant Ajit Kumar Das is running a fertilizer and seed shops of Animat since 2008 in the name of Sahil Mesas Purno Bandar Kishi Kendo. He is also running a wholesale grocery shop at Animat in the name of style of Mr. Purno Bhandar and Sajan San. Before 2004, till date, and he is also working as supplier of soaps and different companies and tobacco since 2004 at Animat. He also opened branch shop of wholesale grocery item, fertilizer item, etc. at that Sajan Sat. In his residential house, apart from that, he has his own car having registered number Sajan Sat of the Sajan Sat, there are so many cars. The one tractor and New Holland company and one hand tractor for plowing the field of for further about 16.40 acres after taking forceful possession. Not only that, the appellant wife is in government employee since 2010. Your petitioners have collected the record of right, photocopies of the registration, and etc. That since I have no regular means of substances of my two brothers and sister except the appellant, herein granted no objection in the form of an affidavit, in my favor, for granting of the license or fair price of dealership, and accordingly after fulfilling the eligible status, I have submitted the application. That since I am running the mobile teacher shop and having no regular means of substance, I have written in my application as unemployed, whereas Ajit Kumar Das has sufficient means to maintain his livelihood. The present material fact is stated that he is unemployed, which is palpably wrong and far from the truth. It is submitted to the appellant as managed the response 6 and accordingly answered. But there are serious allegations that the appellant Ajit Kumar Das during the lifetime of my father somehow managed my father to apply for transfer of the license in his favor. And on the day of hearing, when all the legal heirs have objected and my father had also changed his decision, the hearing was stopped. Further, my father himself thereafter continued the fair I sought the year that due to some ill motive, oblique purpose, and again, instead no objection been granted in favor by other legal heirs, forceful possession, land belonging to your father, and also so many allegations against him. Then kindly come to my lord. Next page. Date 1st February 2000. Shiv Shankar Shah, acceptance of your registration for SK dealership. This is to inform you that your PR suggestion has duly been considered and approved for the interest. So I just do that. That is a question of fact. I do the attention of the authority. Yes, that was there. I didn't suppress anything. But the other brother suppressed everything and being influenced. Now order authority passes an order, which is very painful and very unfortunate. My lord, kindly see, if you also kindly take trouble to page 100, my lord. Serial number 34.
Yes.
What is the total allotment? Kindly see. So many property.
Yes.
Then advice list of SKL. See Satish Chandra Das. Satish Kumar Chandra Das, 2007. Shiv Shankar Das, 109. So, my lord, this is my financial position, which is really very miserable. And kindly come to page 108. These are the number and document that is holding so many cars. Apart from his wife is working as government employee, he may say that, well, or maybe my wife is working, but my position is a question of whether He never shows that I am living separately. Divorce. So they are living jointly. Family includes wife. Kindly take trouble to come. Page 102, 1 second, my lord.
Yes.
Dear my lord, prayer for removal order of unauthorized extra income by ground school. He admitted Gosari. So admitted everything.
2005.
In 2005, can you see the date? 2005 at bottom. 103, my lord. There's so many pairs, my lord. We have annexed all this thing. Nothing has been considered. And now, kindly take tableau pen 104. 104, my lord. Have you got it, my lord? 104.
Yes.
It's whose name?
Column 4.
Memorandum of intimation. Details of notified authority to whom application is submitted. Page number such, Ajit Kumar Das, the other brothers. And then column number or serial number 4. Whether the application is for manufacture and import as a retail dealer, tick mark is there.
Yes.
106.
Kindly take W come 106. Have you got 106?
Yes.
Messrs. Purno Kisi Bhandar.
Yes.
And 2 Ajit Kumar Das in bold letters. Kindly see, my lord.
Yes.
And this
107.
kindly come to 107, my lord. This is another one. Have you got it, my lord?
Yes.
Second box from Messrs. Purno Bhandar and Renuka distributor.
Yes.
And Ajit Das. And next, my lord, the car number, my lord, vehicles number, I've just collected, which cannot be denied. And not been denied.
Number 9.
Yes. Well, even up to 109, my lord, I mentioned, I just annexed the document, card belongs to him. He has not been denied. So he's such a rich man, he can maintain so many vehicles, so many cars. Such a rich man, he is the owner of so many business. And he is claiming that he is unemployed. He is dependable. This is the situation. And he has been obliged. 110 tractor, my lord.
Yes.
111 Bolero. 111 Bolero. That belongs to him. Such a poor man, he can maintain so many vehicles, so many cars, both for commercial and personal use. Now, my lord, ultimately the appeal which was papered, that was this was the final. No, this is the Alada. This is Chaudhuri Kumar. Yes. My lord, page 113.
Yes.
Onwards. In details, it was discussed. I need not disturb your lordships. 114, kindly come to 114, 15, 16. 116, paragraph 9. I need not read the entire judgment to disturb your lordships. 116, paragraph 9. Have you also got it, my lord?
Yes.
From the facts narrated, it is clear that two brothers have filed application for appointment as fares of dealer on compensation ground. Appointment on compensation ground can be given to one if said one is found to be eligible in all respect.
Yes.
I'm grateful. So far as the requirements of filing no objection certificate concerned, well, I am not going to that, my lord, details. Then kindly come to next page, paragraph 11. Paragraph 11, my lord. Before parting with the order, we make it clear. I'm sorry, paragraph 11. Before parting with the order, we make it clear that there is no need of coming to a compositions by the intending parties. The SCFC on inquiry shall recommend issuance of license in favor of the person who is found to be suitable, taking into consideration the rival claim of both appellants and the private respondent, Shivshankar Das, into consideration. It is made clear that the application filed by the parties shall be proceeded within 90 days. So that is a direction by the appeal court. It was disposed of. Now, my lord, the elaborate judgment I need not read because they have discussed what is the effect of no objection. The same. Then kindly come to page 155.
Yes.
Have you also got it, my lord?
Yes, yes.
155. If you have the sole desire, I can read the entire order, but no, I need not. First,
Yes.
reason order, pass in compliance the order, pass the Honorable Justice Calcutta High Court, Chittaranjan Das, and Parthu Saratishi in connection with Sansad. Kindly, these are all and whereas, Baba, it have a lawyer, they will lick it, just shut them. Lick it, see, Ajit Kumar Das and noted other legal layers, Sansad. Then kindly come to next page, 150, next page, 156.
Yes.
Now, I at 156, second paragraph, first paragraph, continuation, can you leave it? Second paragraph, the last two lines. He also admitted, have you also got it, my lord?
156.
156.
Yes.
He also admitted that he had a corruption.
Paragraph.
It should be taken as a first because the last one is continuation at top, my lord, continuation of earlier paragraph. So
Yes.
these pages are first paragraph. It starts whereas Shivshankar Das during hearing could not prove innocent. Then the last line very interesting. He also admitted that he had a kerosene retailer license in his name at the time of death of his power business. I justified, I carry back. My lord, the business which I am doing, if it is not, cannot provide me, then my lord, if he cannot, I cannot maintain my family. That is why I tell aspect. I justified, I surrender. I say this is nothing but a social work, and that is accepted. Then kindly come to last but one paragraph. After inquiry conducted, have you also got it, my lord? After the inquiry conducted by the undersigned as director of the Honorable High Court to find out the dependency of the legal heirs of the deceased dealer, Sri Satish Chandra Das at the time of death of following the observations. Since Badul Chandra Das was the SKL bulk dealer holding license, knows at the time of death of the deceased father, Sri Satish Chandra Das, thus he had means of subsistence and was not only dependent on his deceased father, Sri Satish Chandra Das at the time of death. Hence, requirement of NOC from him doesn't arise. Then, daughter also doesn't arise. During the inquiry, it is found that Sri Tarapada Das has been staying separately from his father, Sri Satish Chandra Das at the time of death, and he was practicing at Fort Kolkata. Oh, Tumi Tarapada. But he is appearing here. I've met him a party, he is appearing. But will also hear him, what is his reaction. If he says, no, I don't want to see the face of Mr. Banerjee's plan, very well, no objections. Then next paragraph, paragraph 4. Of the two applicants, Shivshankar Das was holding a license bearing number Sansad. I surrender, I pointed out this is my income and quantum of liter that was supplied to me. It is impossible to run the business to livelihood, which suggests that he was employed and yet means I could have understood if authority would have stopped there. He was employed. She says had means to subsistence and no fully explained. This is I join issue. There's no inquiry. When I disclose, I place my card that this is the quantum of oil which I received from the authority. And it is impossible to do any business, to run anything. And he said he is not fully dependent. On his disease, after inquiry, death of the was not employed. He was, after inquiry is found, see Ajit Kumar Das, kindly see my lord. Ajit Kumar Das was helping his father, Satish Chandra Das, who corroborated that. Father is gone, father died. Satish Chandra Das in running the APS up to his time of death and was not employed. Kindly marked it, my lord. This is farce. It's an inquiry. I produce all this document. He was not employed. He was dependent on him. Who has corroborated these things? Having so much business, so much money and other things. And wife is also my lord government employee. It is not his case that we are living separately. I am not depending his income on his income. Such and such employed. He was dependent on him. Area inspector during his inquiry at the time of application on his incapacity, Ajit Kumar has also found him unemployed and an affidavit by his father. My lord, father died. And in earlier occasion, it is decided it cannot be accepted. And under the Evidence Act, it is not even admissible. Somehow or other he managed, and it has not been corroborated anything. That's why rightly earlier occasion, authority says, no, gone in the wind. Father died, everything goes, which has never been challenged. Found affidavit by his father, so this was also submitted, stating that he was unemployed and was helping his other son. This is cock and bull stories. Father died, affidavit. And right from 2004 and 5, he's a very affluent person. And all other father that disclose what they're doing, except myself. My position is very precarious. As per clause dependent family members, well, this is the law. Then can come to the last paragraph, my lord here. In this context, this is to note that the Sipsanko Das was already holding a separate Esquire license at the time of death of his father, and also at the time of application for HON'BLE license on compensation ground, thus having means of subsistence and not wholly dependent. Kali marked it, but not wholly dependent, which is very significant. Wholly dependent on his father, Satish Chandra Das, at the time of death. Besides, he failed to secure NOC or dependent legal heirs, that is brothers, Ajit Kumar Das. How the Ajit Kumar Das will, well, see the fun. The person who is trying his level best to deprive me, he will give the no objection. Is it an order? Besides, he failed to secure NOC of dependent
Yes, I
legal
have
heirs.
gone through that.
My lord?
I have gone through that.
I am grateful, my lord. He will issue no objection. Now, kindly see next. Based on all these facts, it is evident that Ajit Kumar Das, son of this and such as does not require. So he doesn't require NOC. Kindly marked it, my lord. The Ajit that doesn't require NOC, but I require, according to him. And the legal heirs of any legal heirs of Satish Chandra Das, as all of them were having means of substance or living separately and not wholly dependent on their fathers and such at the time of such. Hence, application. So, my lord, Ajit Kumar Das application is allowed.
Yes.
And authority of this, he doesn't require no objection, but you require. What is applicable in his case, that is also applicable in my case.
Yes.
What is the logic? All other brothers are not dependable. They are earning separately. Why they are on objection necessary? This is the order, which is very unfortunate, shocking, my lord should say. It's nothing but a table inquiry. And for your lordship's convenience, kindly see. It's not off the record. I have stated in my read petition specifically all these things. A table, a copy there. Sorry. And this is not off the record. For convenience of the Honorable Court, I prepared my note this. On the left side, the Ajit, right side, my client. Kindly see the difference. And still he's claiming he's dependable. And he doesn't require any objection. But what more can be? This is really awfully bad, my lord. This order cannot stand in the eye of law. And I have stated, my lord, not that, my lord, what I am saying of the record. On oath, I have stated, page 12, para 22, kindly comes once, my lord, sorry. My lord say, Mr. Manager, extempore argument I will not accept. Kindly come to page 12, my lord. Have you also got it, my lord?
Page 12.
Para 22. That after going to the said status report, the Honorable Division Bench directed the parties to file an exception to the report submitted. Kindly marked and very relevant, because it was also in the mind of the Honorable Judges that, well, what type of report? So that's why they gave me opportunity to submit a supply korta. And accordingly, the petitioner filed an exception to the said report, stating that a substantial control for a supply korta has made a table inquiry and without conducting any field inquiry, submitted the said status report of gainful information and such. And the status kerosene oil retail license and weekly, it is my case, weekly allotment of kerosene oil in favor of the petitioner, wherein he was allotted only 95 liters to 124 liters of kerosene oil for distribution, which was more like a social work rather than gainful employment. And as such, he surrendered the said license at the state and running a mobile recharge. On the other hand, the responsible, namely, kindly marked it, my lord, Ajit Kumar Das is running a fertilizer seed shop at Ranibad since such and such 2006 in the name of style with a Purno Bandar Kechikendo, and further is also running a grocery shop at Ranibad in the name of style with a Purno Bandar and Renuka distributor, both retail and distributor before 2004. 2004, logically marked it, my lord. It's a false statement, my lord. All along he's making a false statement, and authority being swayed by that.
Yes.
I didn't care to consider all these things. And no, he doesn't require any objection, and he's really very poor man and dependable on his father. How's it? Companies and tobacco companies, which has also open branch of Tansa. Apart from this, he has also his own car having registration number Sansad, the year 2010. That is long before father died. So he's such a poor man, he can purchase the car from his own pocket. And that's why he depends on the father.
Yes.
2010. One tractor and one hand tractor, measuring an area about 16.40 acres of land. He's a poor man, my lord. I'm really surprised. Because after taking for supervision, not only that, the appellant wife is government employee 2010. And he did not take any exception to my exception that, well, yes, all that has been said by Mr. Banerjee can false. So under these circumstances, I am begging your lordships, my lord, that my client may be protected.
Yes.
My learned senior friend has made elaborate submission, but in the chart your lordship will find that whatever the list has been placed before a lordship, that was already considered by the division bench. This is the exception which was filed in the appeal. And after considering that report of the sub-divisional controller and the exception by my learned friend's client and my client, the division bench was of the view that there should be another inquiry by the sub-divisional controller. Now the sub-divisional controller had made an inquiry. Now there is no document thereafter has been annexed to the petition stating that who was gainful employed, who was not gainful employed. Now the writ court, your lordship will not take me amiss, my lord. The writ court, whether I do not know, I'm asking myself, my lord, can go into the question of the facts of the case, my lord, that I am having a car, I am having a bungalow, whatever it is. These documents which have been placed to your lordship, my lord, your lordship will find that these were all the part of the appeal petition, and that have already been considered. Now, where is the scope for consideration of those materials again? There are no fresh materials before this honorable court. Only the material is that this order. Now, what is this order? My lord, let me place before your lordship the relevant clause of the. Your lordship has got the book, my lord. Yes.
My lord, let him show what the court has considered.
Yes.
Page 1.20, my lord, your still kind. Page 1.20.
Yes.
My lord, at the bottom, VI.
Yes.
Engagement on compassionate ground. In case of death or in case of incapacitation on medical grounds subject to satisfaction of the authority of any, or this should be or any existing dealer, prayer of any of the family members, your lordship will kindly mark family members of the deceased incapacitated dealer having no regular means of income may be considered on compassionate ground if such prayer along with formal application in form C2 along with annexure 1 with requisite fee as prescribed in schedule A, corroborative documents as per checklist and no objection from other family member. Again, my lord, your lordship will mark it family member in the form of affidavit to be sworn before a magistrate and access to is submitted. Now, my lord, what is the definition of family member? Your lordship will kindly see. That has been clarified in the judgment also, but I am saying 2M, my lord, at page 1.9.
Yes.
My lord, spouse, parents, son, widow of predeceased son, daughter. Then, my lord, who is wholly dependent on the dealer or distributor at the time of death.
At least your spouse is not wholly dependent on the.
My spouse, I am not in the.
No. You are the applicant.
I am the
You
applicant.
are one of the applicants.
Yes.
So you have not denied that your spouse is not a government employee.
No, my lord, that.
So your spouse, so far as your
This is
spouse,
not
the family member, if you take the definition, if you show me the definition of family member,
yes,
that family member definition is squarely applicable to you also.
Yes, my lord.
So if suppose I admit
My lord.
that you are not gainfully employed,
My lord.
that which clause I do not know how the subdivisional controller found, because it is not a gainful employment which is to be considered. The point of consideration as per clause 6 is that if a person has regular income or not.
Regular means
Regular income and gainfully employed, these are two different things.
My lord.
Number one. Number two is that when any of the family members, so far as you are concerned, if I take into consideration that all the submissions or all the objections made by your adversary, your brother, is false, then also your family member,
my lord, my family member.
your spouse is a government employee.
My lord, kindly see, this is a family member of the deceased dealer, not mine.
So your family member will not be considered at the time of compassionate appointment.
My lord,
that should be that cannot be.
My lord,
I
am placing the statute.
No, that cannot be interpretation of status.
My lord.
This is a court of equity.
My lord.
It is a court of equity, and the court will interpret the statute.
Yes.
For beneficial purpose of everybody.
Right. My lord, that's right. So if the statute provides that the applicant's spouse will also be considered as a family member, my lord, that's why this definition has been given. And this definition has been confirmed by, my lord, the division bench.
Have you seen the judgment of Gurupada Das?
My lord, yes. That's what I'm saying.
Their family member definition has been elaborately explained by the division bench of our.
Yes, my lord, that's what I'm relying. That is what I am relying. Kindly come to Gurupada Das, my lord.
Yes.
Yes. At page 131. 131, my lord. Family member. Now the most important question is, what is the meaning of no objection from the other family members? Family members have been defined in clause 2M. That word, your lordship, I have read out. Means spouse of the deceased, dependent parents of the deceased, dependent sons and daughters of the deceased for the purpose of considering engagement. That has been, my lord, held.
That is a family member of the deceased licensee.
Yes, my lord.
My question is that whether at the time of taking a decision,
my lord,
as to whether you have a means or not, you have a regular income or not, is there any bar to consider that your wife is so-called gainfully employed, being a government employee?
My lord, kindly see the next paragraph. Let me.
It is not the, it is not
No.
the, it is not the purpose of any of the statute that if the husband is unemployed and the wife is employed, it is the statutory duty of the wife to maintain the husband. Statutory duty, section 125, and all provisions under Hindu law, alimony pendente laite,
Yes,
the husband can claim.
Yes, that is there, madam. So, kindly allow me to please this one. Next paragraph. The most important word in the definition is the word dependent. If any of the family member was not dependent on the deceased on the date of his death. Now, my lord, I am sorry a moment. Now, my lord, what is the claim of the applicant? He wants the license. Leave me apart. What is his legal right of getting the license under this clause? I ask myself, my lord. Because he admits that he was holding a license at the time of death of my father. Then he is out of frame. He cannot maintain any writ petition. He has no legal injury.
Yes.
Yeah. Until he has a locus standi to file an writ petition, my lord. This writ petition, my lord, respectful submission, my lord, is not maintained. First. Second, my lord.
Yes.
Second, my lord, the division bench had directed the sub-divisional controller to make an inquiry and to recommend the name of the person whom he finds fit. So there is no infirmity in the order that this order of the Honorable Appeal Court has not been complied with. Pursuant to the order of the Honorable Appeal Court, the inquiry was held and the findings were given. Now, what is the finding? My learned friend has probably not read the entire order. My lord will kindly come to page, last but one page, 157.
Yes.
My lord, paragraph 5. After inquiry, it is found that Ajit Das was helping his father, Sri Satish Chandra Das, in running the fair price shop at the time of death. So that is the relevant thing, my lord, at the time of death, and was not implied. He was dependent on him. Area inspector, during his inquiry at the time of application on incapacitation, Sri Ajit Das was found unemployed, and an affidavit by his father, Sri Satish Chandra Das, was also submitted, stating that he was unemployed and was helping him running fair price shop. Local Gram Pradhan also confirmed that he was helping his father in running the affairs and was living with him and was dependent on him.
Did you deal with that? Did the state authority deal with the application? What was filed during incapacitation of Satish Chandra Das?
Well, that even the inquiry was submitted, inquiry report was not challenged, hearing was given. Unfortunately, before the license could be granted, my father died.
So when your father died and license granted, it goes.
It goes.
So there was no occasion to consider this aspect of the matter.
That is a fresh application, my lord.
No, this is a fresh application. Suppose a fresh a case was filed. Subsequently, that case was anyhow withdrawn or dismissed. Okay. And dismissed without any merit. Dismissed without considering the merit, dismissed for default.
Default. That is there is no
Can subsequently the same plaintiff rely on the document on the basis of which the earlier case was dismissed for default?
My lord.
Dismissed for default. After the expiry of limitation?
Well, after expiry.
Can no finality, this finality.
My lord, until there is a finding about the
that finding, there was no occasion.
There was no occasion.
There was no occasion.
My lord. So there was, my lord, that is my submission, my lord.
How that will be relied upon?
He has that is relied upon only not for this,
So-
but for this to substantiate whether I was unemployed.
Submit, and any other point?
Now, my lord, then
First is question
first.
of
Second, my lord,
maintainability, second is this.
family member who was dependent at the time of death of the deceased.
Yes.
And
Yes.
admittedly, the petitioner was not dependent at the time of death of my father.
Okay,
He has admitted.
okay.
And now, my lord, the question is whether he is getting the license or not. When he was not dependent, he does not come within the purview of the family member.
Yes,
And if he is not a family member, he cannot make application.
yes.
And if his application is turned down on any ground, then he cannot file a writ petition for getting that license.
Yes,
This is my submission.
yes.
When in this regard, so that the dependent is concerned and also making applications to the authority after death. When there is a question of before death, my father was alive. The complaint was lodged by the private private responder Ajit Kumar Das. When the hearing was not it was adjourned when not yet. Subsequently, pursuant to this court's order, the hearing was placed on 27th September 2018. There was the hearing was placed that yes, Additional Controller Supply is there, including the course of hearing, including all the parties. Then the Subordinate Controller submitted that yes, all that record has not been placed in this office. Even we are not concerned of that. Ultimately, they have been rejected of that application for Sikkim Das. Whereas the Ajit Kumar Das has been applied, not in due time, but after that. Even without any meeting of that, the license fee charge or application fee charge, nothing has been done. Even that prior to that in 2005, he is dependent on his own. So far the business is concerned, as my learned friend, senior friend has already submitted all these things. Even that the Ajit Kumar Das, he also having all business, including the other business, holding this. Even 16.49 acres of land has been cultivated.
Yes, this is Ninit. Enough is heard. This is the second round of litigation.
Particularly third round, my lord.
This is the third round of litigation. To determine the issue to determine the issue as to who amongst the family members of deceased FPS license holder is entitled to get. Yes, of course. Deceased is entitled to get license for running FPS shop on compassionate grounds. Full stop. Achha. Next paragraph. At the stage of admission, suffice it to say, suffice it to record that in FMA number 106 of 2022 with FMA number 107 of 2020, the division bench of this court directed the subdivisional controller, food and supplies.
That is 2022, man. 107 of 2022.
Oh, 107 of 2020. 107 of 2022. 106 of 2022 and 107 of 2022. Supplies to consider who amongst the family members of the deceased employee, deceased license holder, dash Shiv Shankar Das or Ajit Kumar Das would be entitled to get license on compassionate ground. Full stop. Achha. The next paragraph, the subdivisional controller held inquiry and decided in favor of Ajit Kumar Das, respondent number 7 herein. To be entitled to have license in his name on compassionate ground. The petitioner has challenged the said finding of the subdivisional controller, food and supplies, Khatra, dated 29th May 2023, on the ground on the grounds of mala fide, non-application of mind, non-consideration of documents filed by the petitioner with regard to regular income of the respondent number 7, respondent number 7. With this full stop, with this challenge, the petitioner has prayed for quashment of the impugned order. Full stop. The learned advocate for respondent number 7 submits that the instant writ petition is not maintainable on the ground that the inquiry was made as per the direction passed by the division bench, and secondly, the original license holder during his lifetime declared Ajit Kumar Das, respondent number 7, unemployed. Full stop. Next paragraph. It appears from the record that the father of the petitioner and respondent number 7, who was the original license holder, died on 18th March 2017. Died on 18th March 2017. Full stop. The petitioner has submitted certain submitted some records showing independent business of the respondent number 7 at Ranibad, full stop. He is also a riot in respect of 16.40 acres of agricultural land. He has considerable income from his business, and he owns 4-wheeler vehicles and tractor in his own name which are prima facie evidence of solvency of the respondent number 7. Moreover, the wife of respondent number 7 is a government employee. The impugned order passed by the subdivisional controller, Food and Supplies, Khatra, does not consider the said documents filed by the present petitioner. Next paragraph. Therefore, the petitioner has every right to challenge an administrative order on the ground of mala fide, causing violation of fundamental and legal right of the petitioner. Therefore, I find that the instant writ petition is maintainable, and accordingly, the same is admitted. The respondents are at liberty to file affidavit in opposition within 3 weeks from the date, and within 3 weeks from the day, and serve the copy of the same to the learned advocate on record for the petitioner as well as respondent number 8, 9, and 10. Full stop. The petitioner and the respondent numbers 8, 9, and 10 are at liberty to file affidavit in reply within 1 week thereafter. Full stop. Next paragraph. In the meantime, there shall be
support picture.
In the meantime, the subdivisional controller, Food and Supplies, Khatra, is restrained from issuing issuing FPS license of the shop in question to either to either of the parties for a period of 6 weeks. So, however, in order to maintain public distribution system,
Already existing
tagged.
system.
It is tagged. Okay,
Yes.
not required then. Next paragraph. The 3 সপ্তাহ এদিকে গেল 1 সপ্তাহ the writ petition be listed in the on 7th August 2023.
My lord, may I make a suggestion? The lordship will kindly record that petitioner is also was also holding a kerosene license at the time of death.
Yes, ওই একটা এতে লিখে দেবেন তো যে the petitioner was also holding kerosene license in his name, which he subsequently surrendered.
And the respondent numbers 8, 9, 10 was.
In the year 2018.
Fine.
Stated, your name will be recorded.
If you like.
3:14 হয়ে গেল এই একটা মিনিট হ্যাঁ আর 3টের সময় একটা স্পেশাল ইফেক্ট ছিল না আজ তো 3:30 তাহলে যেটা 3টের সময় স্পেশাল ইফেক্ট ছিল আবার কালকে থাকবে মানে ইয়ে করে নেবেন your matter na which was specially fixed at 3 p.m.
I have no problem, but respondent Yes. MBA was saying they have got some difficulty tomorrow at this.
Tomorrow? Yes?
Not tomorrow, Lordship. Kindly on
Thursday.
Thursday.
Thursday at 2 p.m.
No.
Due to health concern,
Thursday at 3 p.m.
3 PM হবে না আবার গন্ডগোল হয়ে যাবে।
কিছু হবে
না।
actually,
What's this?
Lordship, due to
What's
health-
this? Why are you saying Nana
No.
within the hearing of the court? That is not proper. I have fixed at 3 p.m. and I shall hear the matter at 3 p.m. If required up to 5:30 p.m. I shall conclude the hearing of Mr. Bera on Thursday. নিন Thursday আছে কিছু 3টের সময়।
At 2 PM, my lord, that Thursday at 3 PM.
Thursday at 3 p.m.
2 PM at Pathard, my lord, my matter is.
2 p.m. at Pathard. Today at 3:30 it is not possible. Yes, it will be tomorrow, and there are 2 review matters. Let me see. কই দিয়ে দিন। Other matters are released
And my matter will appear on
tomorrow.
at 2 PM, my lord.
Lord, I am for the school authority. Sir, penalty is taken on behalf of the
What is the matter about? Why review?
No, that matter. I'm grateful, my lord. I was absent. My lord has protected me, my lord, deeply obliged.
Yes.
Now, my lord, review, as I already stated, my lord. And from the language of the order 47 appears, it was not the
Any other sufficient ground?
any other subject. Not only that, court has not been blamed by the court or the legislature. But normally, when you prefer an appeal, you say the court at the first is hard in law, hard in such and such. But review it need not. Question is this: if suppose today X file a suit against Y for certain relief, by suppressing certain document and keeping the court outside this, my lord, he got an degree. Subsequently, if it is pointed out, error on the face of the record, because it was not even pointed out to your lordships, then document which was not available, then sufficient is to what extent, to what effect. I just pointed to losses, my lord. I cited some judgment, a jealous copy, as there I do a loss in attentions that well, the judgment which is delivered prior to judgment delivered by your lordships, even the same line, naturally court can take it as sufficient reasons. But if it is delivered after your lordship judgment, no, on that ground review doesn't lie. Because I delivered a judgment on 1st January, judgment of the Supreme Court or other High Court delivered on 10 January, that can be taken into considerations. I just pointed out, my lord, that well, even if I do not the writ applications, could my relief to be extended, and my lord also did it in other 2 cases. My lord, sorry, my lord, I'm sorry. In other 2 cases, my lord granted the same relief, that it to be same relief to be given in a mandatory form to be given. In my case, I must finally confess one thing. Should I, my lord, as a lawyer,
Yes.
Mr. Bari appeared in all the cases. The very first day, my lord, very right, my lord just the joke told me, "Ami online ki kori the review mane as if online." No, other 2 persons in whose favor the order is not passed, which is passed by your lordship. Other 4 matters appeared. The other these clients making what wrong we have committed.
No, in other 2 judgment matters, what was the order passed?
Same thing.
My lord, 4 matters appeared.
Yes.
I concluded my submission. As my lord, I had to catch the flight. And my lord, afterwards, your lordship delivered the judgment.
Yes.
Had it been, my lord, I strongly believe, my lord, had it been my presence was there, your lordship would have changed your lordship's mind. Other 2 matters, where similarly placed, similarly circumstances, your lordship passed a mandatory order, where first time approached the court. And here, my lord, the second time, the authority rejected our prayer for approval, and your lordship delegated the matter, that authority again. That is the subject matter of the challenge.
And
again, when did they file the representation, which was the order, maybe second time, did they file any representation before?
No, before that we filed the review applications for this reasons.
Before that, you have filed the review
That's true.
application.
This is a review application.
So what are the orders
That's
passed in other two matters?
যাও তো ভাই
And relying এটা দিয়ে দাও
আগে আস্তে আস্তে দাঁড়াও these are the two order my lord.
দেখে দুটো দিয়ে
ওই জাজমেন্ট লাগে দে সুপ্রিম
কোর্ট গুলো আপনার এখানে
ওগুলো লাগে দে
Yes.
Now, my lord, on the last occasion, I just cited one judgment of your lordship, 87, 86 Supreme Court.
Yes.
Three judges bench. The
Yes.
power of your lordship is under Article 26. I just handed over. Well, do you have a copy of the judgment, my lord?
No, I don't have the copy of the.
I am sorry, my lord. Then kindly take it, my lord. Kindly keep it your lordship, my
On
lord.
the last occasion, did you? No, you did not give me.
Now, my lord, kindly take double to come paragraph 19. It's a very interesting judgment. I like it like anything. Because as we know, my lord, power of your lordship to some extent much more wider than the power of our Supreme Court, super Article 32 and 226. Article 32 only foreigner cannot challenge anything. But 226, a foreigner can come and challenge any arbitrary actions, not the fundamental right. Now, kindly come to paragraph 19, my lord. Last no. Have you also got it, my lord?
Yes.
It starts with the in Halsbury, my lord. In Halsbury's laws of England, just above the paragraph 20, my lord.
Yes.
In Halsbury laws of England, 4th edition, volume 1, it is stated that the purpose of an order of mandamus is to remedy defect of justice, and accordingly it will issue to the end that justice may be done in all cases where there is a specific legal right and no specific legal remedy for enforcing that right, and it may issue in cases where, although there is an alternative legal remedy, yet that mode of redress is less convenient, beneficial, and effectual. There is thus no doubt that the High Court in India, exercising their jurisdiction on Article 26, have the power to issue a writ of mandamus or writ in the nature of mandamus, or to pass order and give necessary directions where the government or a public authority has failed to exercise or has wrongly exercised the discretions conferred upon it by statute or a rule or policy decisions of the government, or has exercised such discretions malified or an irrelevant considerations, or by ignoring the relevant considerations and material, or in such a manner as to frustrate the object of conferring such discretions or the policy for implementing which such discretion has been conferred. In all such cases, and in any other fit and proper case, the High Court can, in the exercise of its jurisdiction Article 26, issue a writ of mandamus or writ in the nature of mandamus, or pass order and give directions to compel the performance in a proper and lawful manner of the discretion conferred upon the government or the public authority. And in a proper case, in order to prevent the injustice resulting to the concerned parties, the court may itself pass an order or give directions which the government or the public authority should have passed or given had it properly and lawfully exercised decisions. So, my lord, the authority which can pass, court can also pass this order. I am here to keep the protections of the parties. Now, my lord, what is actually happened, my lord? So far the Supreme Court is concerned, I just point out losses, my lord. It's very short. Second page the করেছিস আচ্ছা ঠিক আছে why I'm kindly the last all India services in this. The benefit of this order, just have the paragraph 2, my lord. The benefit, I will also got it, my lord. Last, the benefit of this order shall be extended to all such employees, including those who have retired and those who have not joined as petitioner hearing. So we are supposed to, if I do not join, it is not the court will take the responsibility. It's the duty of the authority. Once it is done, maybe in implementing the order of your lordship, pass the order. That means whoever the similarly placed, they must do it, they can do it. So these judgment was pass the order. If the order judgment is passed after passing of the order, the review doesn't lie. And another judgment which I cited, my lord, thus is এর একটা কপি করে দিস ইয়েস এটা দাও তো ভাই
1987. Yes.
My lord, first, my lord, question of natural justice also discussed by the court, and then the elaborate judgment here also the same thing can be extended, and part of the natural justice. এটা মার্ক করা ছিল এটা পাল্টে না না অন্য এটা দিয়ে আছে ধর প্যারাগ্রাফ
19 and 20 paragraph.
I'm deeply obliged, my lord.
আর এটা রিলাইং ইন ওইটাকে রিলাই কর নবদ্বীপ প্যারাগ্রাফ 8.
Now, my lord, the last but not the least, another judgment, a copy আছে.
প্যারাগ্রাফ 8.
Kindly, this is very interesting, my lord. The judgment is our High Court, my lord, relying on the judgment.
Right. Referring back to the matter, use this paragraph. Right.
Now, have you got it, my lord? Now, kindly take time to come paragraph 8.
Yes.
I must frankly confess, my lord, I am not criticizing any order or anything. Had it been a case, it was pointed out losses, naturally, my lord, because it is our fault, my lord. I must frankly confess. No question of hiding. The view taken by the learned trial judge had chosen not to send the matter back to the state authority, and the view of the learned judge is fully supported by the decision of the Supreme Court in case number such and such, which I have cited, whereupon the Supreme Court had observed, it is common experience that once a decision has been taken, there is a tendency to uphold it, and the representation may not be yield any foot progress. Kindly see, my lord, even our chief justice and other some judges has expressed their agony. What is going on? We are passing the order. Now we will take the responsibility. We need not initially thought, because you, the people, you are the administrative officer, you must do it. But every time we will direct and they will not follow. Some or other 11. Now we will take the responsibility. We will pass the order. So that's why, my lord,
2015 one, same benefits must be given to all other employees.
my lord, now,
Paragraph by 22.1 to 22.3.
now, 2015 once rule. These are the people passing lawsuit order. Paragraph and copy koi. Copy to দিয়ে দেয় যাচ্ছে
এটা দেখুন আমাদের
আর জাজ সাহেবের কপিটা দিই
22.1 থেকে এটা দেন 22.1 থেকে ওটা এটা আমরা
না 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 আচ্ছা মানে 22.1
page 363
22.1.
Yes.
Have you got it, my lord? 21. The normal rule is that when a particular set of employees is given relief by the court, all other identically situated persons need to be treated alike by extending that benefit. Not doing so would amount to discrimination and would be violating Article 4 of the Constitution of India. These principles need to be applied in service matter, more particularly as the service jurisprudence evolved by this court from time to time postulate that all similarly situated persons should be treated similarly, therefore. Well, these are the same lines, Supreme Court oral judgment. Now, my lord, regarding the word service jurisprudence, had a bitter experience. I just started arguing with Justice Indira Banerjee when he was the judge of the High Court. Recently elevated him. When I say service jurisprudence, what you are introducing here? Because with all respect, he has not much accord with the service matter, other matters. Hurry, what is service jurisprudence? Well, there is a service jurisprudence. Then the very next day, Mr. Sukhdev Mukherjee appeared. He argued for 2 hours regarding, I'm told by other gentleman as a lawyer, service jurisprudence. Then she realized, yes, service jurisprudence is there. So it happens, nothing wrong. I said, no, it's all right. I don't mind. But the question is, my lord, normally in the case of review, most of the time judges view that, oh, you are trying to find out my fault. No, this is not that. Had there been intention on the part of the legislature to direct the court through code COD that, well, you have committed a wrong, you must. That is not the case. See the language, it is at the cost of repetition. Language is quite far from that. It is not the fault on the part of the court. To some extent, it is the fault on the part of the lawyer and counsel, I should say, because a judge not supposed to know everything and anything. Every day, several type of cases are being argued before the judge. Several judgments are cited. Something may miss. So here, my lord, we are saying, my lord, at the same time, why not paper an appeal? My lord, as soon as we will paper an appeal, I will say something. I president no. This is not proper, my
second matter, RVW 4 up to it is similar.
And
দুটো matter আমাকে ভেতরে দিয়ে দিন।
relying your lordship's judgment, the mandatory order, 3 coordinated bench passed the judgment. I handed up.
Yes, এখানে দিয়ে দিন এখানে। ওই
We are grateful, my lord.
ওই এটা
The other judges relied on your lordship's order. তাহলে আমি কি অপরাধ করলাম হুজুর? চার্জ বলে সাতকুন মাপ আর ওসমানী বলে হবে না।
এই দুটো আর ওইটা একসঙ্গে বেঁধে আমাকে ঘরে দিয়ে দিন। আর শ্রীমাধব, যেটা আজকে আমি ডিকটেশন বড়টা যেটা ডিকটেশন দিচ্ছিলাম, ওটা যতখানি আপনারা মানে করে যদি শেষ হয় আর কি, ওটা কম্পাইল করে আমাকে পাঠিয়ে দিন। আমি ফাইনাল লাস্ট এটা ডিকটেশন না তাহলে শুরু করুন, শুরু করে আজকে না হোক কালকে পাঠাবো।
অসুবিধা
Yes,
করলো তো
remaining